Welcome to Sovereign Citizen Legal Encounters. Glad to see everybody in the chat. Hope everybody had a good weekend. Okay. Just gonna have some fun tonight. I got two hearings for you tonight. Okay. So we have one of a case last year of a guy that was in Judge King's court, but along with you'll see him through the magistrate process at first. And then after that, he'll be in Judge King court for the rest of it. Now, I will say it's a charge that you're not going to like, but it is muted. And then after they say the charges, that's pretty much it. And they may go into it one more time. And I have a second case I'm running tonight where I actually did this case last year out of Judge Morales' court. And there's a sovereign citizen, Moorish, that was in there. He never came to his last court hearing. And he finally got arrested. I've been waiting for months for this guy. So I'm just going to show the case, and then I'll have some documentation of his bond and that kind of stuff. But he's due to come back to court, but not yet. It's going to be a few weeks. And also for the update, it should be some court cases coming to you this week, some more follow-ups, some stuff that we've been already following and watching. So we're going to take it from there. So I hope I'm seeing everybody. Hello to everybody that's here. I appreciate y'all coming out, hanging out with me. So this case, the first case is from last year, and the other case is from last year that I had originally followed. Okay, so the one you about to watch now, somebody brought it to me and was like, hey, you might want to check into this. So I gathered all the hearings because I never seen it before. So it's just a fun night for us to hang out as usual. All right, so let's get into it.
What's his name?
The beneficiary.
Yeah, first name is the beneficiary.
Are you stating that the trust that we are administrating is the Kevin Pollard Trust? If so,
I'm asking what your name is.
my name is the beneficiary of the trust.
Of whose trust?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor?
Okay, I'm
so,
gonna recall him. Bring up somebody else. Put him aside. We'll call him at the end.
Thank you, Judge.
Sir, is your name the beneficiary, Kevin Teron Anthony Pollard? Yes or no?
I'm the beneficiary of the trust, Your Honor. Are you stating that the trust that we are now administrating is the Kevin Pollard Trust?
Are you Kevin Pollard? I'm asking you.
Is the trust that we are now administrating?
Sir, I ask the questions here. You give me yes or no answers.
You're asking for my permission to
ask the questions. You give the answers. Is that clear?
It's very clear.
Okay, listen.
Yes.
Are you also known by the name of Kevin Pollard amongst other names? Yes or no?
Are you stating that the trust that we are now administrating is the Kevin Pollard Trust, Your Honor? If so, Kevin Pollard is in fact present today. It is you that is Kevin Pollard, Your Honor. It is you.
Really?
Yes, Your Honor.
Really?
It is you that is Kevin Pollard. Yes, Your Honor. You are Kevin Pollard today, Your Honor. I am the beneficiary.
And then who are you?
I am the beneficiary of the trust.
Okay, well, Mr. Beneficiary, take you and your trust back to jail.
I have some questions for the clerk, Your Honor.
No.
I have. Can I speak to the clerk before we go any further?
You know what? I'm gonna put you in timeout. Get your mind right.
I gotta say, this magistrate right here, he don't play around with him, but he also plays around with him, if you know what I mean. Like he kind of, if they mess with him, he's gonna mess with him back. That's what I like about this guy.
Mr. Pollard?
Yes, sir. Can I have the clerk present? Please, Your Honor.
Don't give in.
Please have the clerk present in a Zoom meeting.
You know what? If you answer my questions, I'll consider it.
Okay. What's the question?
What's your name?
The beneficiary.
All right, Mr. Beneficiary, put you back in timeout. All right, beneficiary. I'm going to give you another chance in front of another magistrate.
That's no problem. Can I have the clerk present, please?
Hey, sir, I'm Magistrate Chartea.
Excuse
DDC.
me? Yeah.
I'm talking to the DDC officer.
Yes.
DDC?
Yes, ma'am.
They switched up, like they tag teaming this guy. This is funny.
Okay. The gentleman that is in front of the screen, in front of camera one, what name do you have him listed as?
Kevin Pollard.
Do you have a middle name?
No, ma'am.
Okay, so you have a Kevin Pollard. Okay, and sir, you're identified as Kevin Pollard, but you're considering yourself the beneficiary. Is that correct, sir?
Are we on the record?
We are. Everything is on the record.
Okay. Are you stating that the trust that we are now administrating is the Kevin Pollard trust, ma'am?
I'm not administrating any trust because there is no trust in front of me. But what I'm asking you is, you call yourself the beneficiary. Is that correct?
Yes, Your Honor.
Okay, no problem. I have case number is 240-5538101. People of the state of Michigan versus Kevin Theron Anthony Pollard, who
Your
is
Honor,
listed by DDC as Kevin Pollard. However, the gentleman has identified himself as the beneficiary.
You representing as Kevin Pollard today, Your Honor.
Mr. Pollard,
I'm not.
Mr. Pollard, now as your counsel, I am going to advise that you stop speaking and allow the judge to speak.
Yes, ma'am.
Counsel Kirkland.
Good afternoon, Your Honor. Shava Kirkland on behalf of Mr. Pollard, who has been advised of his rights, wishes to stand mute and waive the formal reading.
Thank you. I'm going to enter plea of not guilty. February 2nd, 2024. It is a probable cause conference followed by preliminary examination. February 8th, 1:30 p.m. Both matters are in front of Judge King. The probable cause conference, it is at 8:30 in the morning. Mr. Beneficiary, you should not talk over to the court. I thank you very much.
You are under oath and you are on record. And I'm asking you,
beneficiary, I have not sworn you under oath. I am under oath, so I am doing all this. I'm going to enter plea of not guilty. I already given the court dates while this case is pending, sir. Okay, there should be no contact with the individual.
You are not allowed to state what the judgment is. That is my job.
Mr. Pollard, I do want to let you know that the person.
Okay.
I have a question for the clerk.
Okay.
I have a question for the clerk. I have a question for the clerk.
You will give an opportunity, sir. You will give an opportunity. Let me finish. While this case is pending, there's no contact with that means no person contact, no contact with third parties, no phone calls, no emails, no text messaging. The people, go ahead, Esteban.
Yeah, the people are asking for $250,000 cash bond, no cash, no surety. If he's able to ever post bond, we'd like GPS tether with home arrest. The defendant, Your Honor, has a continuing situation where he entices young girls on the internet from Arizona in this particular case, and previously on 10/23/2023 in another case where he enticed people. He's been arrested 3 different times for criminal sexual conduct. The first case, he was found not guilty back on 5/15/2015.
Hold up. Aqua Queen already took care of it. Hey, Squeegee, I'm going to answer your question because I like answering these questions. So why am I playing something old from last year? Because I never seen it, and we're enjoying it over here. Now, you can join us if you like, or, it's up to you. I'm not mad at you. But this is a video I haven't seen. It is funny for the most part, except for his charges. So you can hang out with us if you like.
10/21/2023 case where he was criminal sexual conduct first degree and also contributing alcohol to a minor. 2 counts of that was at the exam. dismissed without prejudice. My belief in all that is because these victims all live out of state. In our particular case we have here today, Your Honor, the victim is from Arizona. She came here after having a relationship, not the victim, but one of the witnesses came here after having a 3-year relationship with this defendant on the internet. When she turned 18, she came to visit. And also, Mr. Pollard introduced her to another girl who is also from Arizona. The other girl brought her niece or her, I forgot the relationship, but her 7-year-old niece with her to visit Mr. Pollard. And what happened then, because the person was tired from traveling, she fell asleep in the living room. When she woke up, she went into the bedroom, and there was Mr. Pollard with the 7-year-old girl.
Well, off that negative note, let's go with a positive note. Thank you, Trish. I appreciate that. I'm going to try to keep up the good work. You know, we make it funny here. We have fun here, okay? If people come in and don't want to have fun with us, I'm not going to say the rest. I'll let y'all say it in the chat.
He then said, "What are you doing?" And he says, "Well, we're playing video games." So the woman, the adult in the room, she falls asleep again. And then she is awakened by the 7-year-old girl and asked to leave. The 7-year-old girl then tells her mother that Mr. Pollard touched her, rubbed her, he says, okay? He said, you know, accidentally is what he's trying to tell us what happened. The situation is she's told, the 7-year-old child has told TED Talk that he did this. He's told Protective Services that he did this. And as far as I'm concerned, Judge, he fits the category of a predator because he did the same thing in the 1023-2023 case of enticing young people from other parts of the country, perhaps, I don't know where exactly, to come and see him on the internet. So we're asking for $250,000 cash bond, no surety, and GPS Taylor, if he's ever be able to post bond. Thank you.
Okay, I want to go ahead because it's posted up on here. Hold on a second. Aqua Queen, 4 months, huh? 4 months. Thank you for sticking around for 4 months. The longer you here, the more you become into the beneficiary of the trust. Okay? So just keep hanging around. Appreciate that.
Okay. One question, Councilor Ragnan.
Yes.
Does he have any pending cases?
Not that I know of, Your Honor. The 1023 case, 1021-2023 case has been dismissed without prejudice at the exam, and I couldn't find out it was because the witness was, if the witness was out of town or what the problem was, but.
Okay.
Thank you.
Thank you. Okay. Council Kirkland, go ahead, Esteban, please.
Thank you, Your Honor. I'd ask this court, understanding the seriousness of these charges, for a 10% bond if this court is not inclined to do a high personal bond. So one, I know the bulk of Brother Counsel's argument was this dismissed case from last year. I'd ask that this court sentence him based on these allegations and the facts and details surrounding this case. This is a 2020 case. And the woman that he met was 20 years old, or that came to see him was a 20-year-old woman, was not an underage woman. And the allegation is that she brought her, I believe, goddaughter to the home. Now, there are different variations because a couple different stories are told as to what occurred there. But Mr. Pollard has maintained that he didn't actually assault the little girl. I'm not sure why this case wasn't charged until 2024, but it is a 4-year-old case. My understanding is that he, I don't believe he's had any convictions since then. He is a lifelong resident, has a child, so he has strong ties to the community. He also owns a lawn service here. At this point, there's no amount of bond that he can't afford to pay. So even a 10% bond would be unaffordable for him. But given the age of this case and his lack of issues since this, I'd ask this court consider a high personal bond, if not that, a 10% bond.
Thank you. I've heard the representations from both sides in this particular matter in reference to the beneficiary who is listed by the court or by DDC as Kevin Pollard, is that in this particular matter, even though this is from 2020, okay, there was a forensic interview, Kids Talk, with the victim, and she disclosed that she was touched by the defendant and that he rubbed her with his hand. This court is not considering the other cases that were dismissed without prejudice. Okay, this court is only going with this matter. In reference to this gentleman, the defendant, bond is going to be $250,000 cash. There's going to be a GPS tether, home arrest. Further, okay, it's going to be unaffordable. So today is Friday. He's going to get another court date. Today's the 26th, January 29th, 2024, 9 o'clock in front of Judge McConicle, who's going to be looking at the bond amount and bond conditions. Also, there is one other thing. This court looks at clear and convincing evidence standard, okay, based on the representation, based on the reading. This court is convinced that Mr. Pollard, okay, I'm sorry, the beneficiary, okay, that he is a creditor in this particular matter. That's why we're putting at $250,000 cash, GPS tether, house arrest. He does have the, again, the unaffordable bond redetermination for this Monday, January 29th, 2024, 9 o'clock in front of Judge McConicle. Also, there's another bond condition. He's not to be around any minor children. That concludes the arraignment of the beneficiary, also known as Kevin Pollard. Madam Clerk.
Pretrial, Your
You
Honor.
wish to talk to the gentleman that's in
Judge,
front of the screen.
Judge.
Okay.
Pretrial and
Just so
examination.
for the record, is that the clerk has declined to talk to the gentleman in front of the screen.
No, that is not
concludes his
fair.
arraignment. Thank
That
you.
is not fair.
Oh, now he whining about it's not fair. So I wanted to explain the case, and I would assume that maybe all of you know it, but a forensic interview with a child is when someone, say social services or whatever you call it in your state, they have a way of interviewing these children to find out what goes on. So it's like a strategic way of interviewing them instead of just saying, hey, did he touch you? They don't go about it that way. They have a line of questioning that normally pulls out the truth for the most part. So when they get it and it's forensically done, normally they're on point.
You cannot do this. Under oath and on record, you cannot do this. I have rights, and you violated them, and you was not my judge.
Okay, you can go. Go ahead and do whatever.
You cannot do that.
Okay.
As the beneficiary, I asked.
I'm sorry.
Can we have those dates again? We couldn't hear them.
Over the dates.
February 2nd, February 8th.
February 2nd, February 8th. Bond redetermination Monday.
Of this QV trust account that she are.
Huh? What you say?
See how he plays with them? I guess the other magistrate was like, let me jump in there real quick. Let me handle it. Oh yeah, I appreciate that, Tage, what you said. I'm glad I'm your favorite Salsa channel. So yeah, we're going into Judge McConicle, and we're going to probably hear a little bit more of this case just to give you a heads up. But yeah, that dude, his bond should be higher, and the fact that it's 4 years old. So I don't know how it ran that long. I don't know if he was doing this sovereign citizen thing and it just kept getting just, like rescheduled. I don't know. I only got it from back to where I could find these clips and I had to put them all together. All right, let's go.
What is the bond for your client? Is it 250?
Cash, that's correct.
Argument.
Judge, my client's 38 years of age. He's on Social Security disability, Judge. I don't see any criminal history for Mr. Pollard, Your Honor. He lives in the city, does have a child. Your Honor, this alleged incident occurred back in 2020. So it's some 4 years ago. Obviously, it's a serious case, obviously. But it's 4 years old, Judge. He has no priors. I'm asking respectfully for a reduction in bond. The bond is $250,000 cash. Judge, I know the court will impose a GPS tether. I already know that, Judge. My client, in fact, Judge, he has a tether already on. He has a tether already on. Let me be clear about that. There's a misdemeanor, and I apologize, Judge, if I said something wrong initially. There's a misdemeanor that he has the tether for, so it's a misdemeanor.
Okay.
Your Honor. And he does a lawn care service, so he does have some work that he does, but the court doesn't have to worry about tether. I'm just asking for a reduction in bond to either a high part, some type of 10% bond. I think 250,000, Judge, is excessive. Thank you.
Okay. Mr. Prosecutor.
Judge, the defendant on the screen today in the top left, he's being charged with sexually assaulting a 7-year-old. The assault allegedly happened at his house in his bed. Your Honor, this is an individual who allegedly is self-proclaimed part of the tribe of Judah. This is also an individual that I actually had the opportunity to watch the arraignment regarding the defendant in this case, gave the magistrate such a hard time that multiple magistrates actually ended up having to handle the matter because he wouldn't give up his name or his identity. Now, being charged with this and now knowing what his past is like, I may refrain from giving a magistrate or a judge my name as well. Because, Judge, the situation that Mr. Reagan is talking about that the defendant's involved in right now, it has to do with selling and furnishing alcohol to minors, to a 12-year-old and 14-year-old. It actually originally began as a criminal sexual conduct first degree where the defendant allegedly was having sex with the 12-year-old. But Your Honor, based on apparently the idea that somebody didn't appear at a hearing, it was reduced to the selling and furnishing of the alcohol. So he has an ongoing matter right now, Judge. He's on bond. We have this particular matter, allegedly, where this individual ended up touching a 7-year-old's vagina. We have corroboration to that, Judge. And Your Honor, with all due respect, the way that the people see this defendant based on previously being charged, now being charged with another CSE first degree, we find him to be a predator. Not only that, Judge, we find him to be mentally unstable. He's currently on a case regarding minors, 12 and 14 years old, and just plain and simple, Judge, we find him to be a danger to the community. Therefore, Judge, we do feel as though a high cash bond is appropriate. We do feel as though the magistrate got it right here in terms of the 250,000 cash, not just to this particular complainant, but kids, all kids. This is one of those individuals where we feel as though he poses a danger to everybody.
See, where we I haven't heard their arguments of counsel, where this gets a little dicey for concerning bond is that we have a situation where the defendant allegedly, I guess an 18-year-old comes in town to visit with him for her birthday. She turned 18, so she comes to see the 37-year-old who she's been in a long-term relationship with for the last 3 years. So I guess he would have been 34 starting the relationship with the 15-year-old. Allegedly, she talks to a friend and they come over and the 7-year-old is over. The girl comes and finds the two of them in the bed, and then the mother contacts a person asking who is this Kevin guy, because her daughter says he touched her vagina. So, and then we have another case of furnishing alcohol to 12-year-olds, and whether there's sex there or not sex there. We have a pattern that's a little bit concerning. It's a lot of minors, a lot of alcohol, a lot of sex allegations, a lot of molestation allegations, a lot of flying people in who are kids and teenagers. And so we're real concerned about this. So the $250,000 bond is an unaffordable bond. And so the court does find that this defendant is a danger to all kids. He's just a danger. The court is going to disagree with the magistrate on this, and I know the magistrate or magistrates had some issues with this defendant, and they used the information that they had at this time to come up with the $250,000 bond. But the court does find that Mr. Pollard poses a great danger to the community. And a $250,000 bond is unaffordable, but it's not enough. It's not enough. So what we're going to do is we're going to add some to it to make sure he's incapacitated. But if he posts the bond, then that means we know that he'll appear for court. So the bond is going to be increased to $1 million, and that'll be $1 million cash. If he makes the $1 million, then he'll be placed under house arrest with GPS tethering. Mr. Pollard is not to have any interactions with anyone under the age of 18, whether they're family, whether he knows them. He's not to be around anyone under the age of 18. If he is, that will violate his bond.
Well, he's going to have to cut a lot of grass to get that money, but he indoors now. He's not going to be able to get that. And I'm glad during the time that this hearing came that they raised it to $1 million, because that is some terrible behavior. And he apparently has a habit of it. And we need to keep people like that off the streets.
Thank you.
So Judge, the bond was 250,000 cash.
Yeah. And then now it's $1 million cash. Now it's $1 million cash.
Okay.
It's $1 million now. It's $1 million now.
Okay, because he's on Social Security disability now. Can't afford
I
it.
understand. But the court finds that Mr. Pollard, it may be some serial action is going on right here. And I don't really know if he's like a serial rapist. I don't know if there are other children that he just lays in the bed with allegedly and touches, or there's other 12-year-olds, or if he's flying other 18-year-olds out to celebrate their birthday. I'm not sure. So what we have to do is we're going to err on the side of caution and make sure that Mr. Pollard is not able, at least right now, to be able to engage or even be charged with engaging in these type of activities.
Yeah, no, Judge, I get it. I know it's rough when the allegations are from January of 2020, but the prosecutor doesn't charge until January 24th. I mean,
it's when it looks like it wasn't until October 14th of 2023 when the mother called asking, who is this Kevin guy? So that we just kind of got that information. And I'm not sure when the 12-year-old, I'm not sure when all the 12-year-old and the alcohol, when that happened. So it's a lot, Mr. Reagan. And so the timeline may get a little bit jumbled, but it's a lot of kids, teenagers, alcohol, sex, molestation. It's kind of blending. And so, we're here where we are.
Now we get the answer to the 4 years. It wasn't because of the sovereign citizen stuff. But at the same time, when people go through that kind of stuff, it could take years before they decide they want to come forward with that, because it messes with them mentally and they go through a lot of stuff. And sometimes they don't even tell people about those incidents. And then they start acting out and you don't know why the child is acting out. And then it just takes a long time. So I'm glad, it finally came to light. But that person could have held that till they were 18, 20 years old, and it happens.
Yes, sir.
Right, thank you. Ms. Pollard, you can leave.
They realized it was that close to the end. So, yeah, we have another hearing with him where this case is just still moving forward. But, yeah, with this stuff, yeah, it's bad. I don't like that at all. Oh, so let me make sure I say it right. Jalen Player, huh? Jalen Player. Okay, I appreciate that, Jalen Player. I don't know what you play as an instrument. I don't know, but thank you. I appreciate it. All right, so we're going into the next hearing with this guy. In spite of what's going on with the charges, I try to at least lighten it up by saying some stuff, but none of this stuff is funny. It's just him with his sovereign citizen stuff is what I'm focusing on. But I'm glad that, they've been taking care of this. But we're going to see how this case pans out for the ones who haven't seen it.
Appearances for the record.
Oh, another squid gifted 5 memberships. Thank you. So I hope somebody in here, there it is. And y'all know I'm going to read it off because it's only fair. So it's Avalanche, Lisa, Alicia, Mary, Anderson the Great. I'm glad y'all were gifted the memberships. So yeah, y'all can check out stuff that's in the community post too. Also, but I'll get into other stuff later. Okay. So congratulations. Welcome.
please.
Good morning, Your Honor. Shelley Drain for the People, P number 60249. I'm standing in for the Attorney of Record, Assistant Prosecuting Attorney Erica Moses.
And good morning, Your Honor. Nicole James, appearing on behalf of Mr. Pollard. My P number is 58961.
All right. What's your pleasure, counsel? Oh, Mr. Pollard, unmute yourself and tell us your name, sir. Mr. Pollard. Have them unmute you so you can tell us your name. Tell me your name, sir.
I exercise my right to remain silent.
You don't want to tell us your name?
I'm the beneficiary
Beneficiary of what?
of the trust that we are now here to administrate.
Okay, that's fine. Can you tell me your name?
Excuse me?
Can you tell me your name?
The beneficiary of the trust, Your Honor. I'm not
Beneficiary of trust?
I'm not coming here as the name. I'm summoned as the state trust. It'll be a contradiction.
I'm looking for Kevin Pollard. If he's not here, I will KPS him.
Your Honor, you are appearing as Kevin Pollard today.
No, I'm not. My name is Kenneth King.
No, Your Honor, you are the trustee of the the trust that we are now here to administrate. It is a
I have no idea what you're talking about, sir. I'm just looking for Kevin Pollard. If you're not him, then I'll issue an arrest warrant for Kevin Pollard because he's supposed to be here.
Under trust law, it's a contradiction for one to be the beneficiary and the trustee, Your Honor.
All right, you're talking a different language to me. I have no idea what you're talking about. Miss James, how would you like to proceed?
Judge, originally I was going to ask it to be set for a preliminary examination, but it sounds like it may be a competency issue.
Oh.
So, Judge, what I'm going to ask the court to do, I have an appointment to meet with Mr. Pollard this afternoon. I'm going to ask the court if we can set an exam date, but we can also set Monday as a review date.
Hey, why don't we just do that before we set an exam date?
Okay.
The court will adjourn the probable cause conference. If you're able to find Mr. Pollard, we'll adjourn the probable cause conference to February 5th at 8:30.
Yes, Your Honor.
If you find Mr. Pollard, then I will issue a case for his arrest.
Yes, Your Honor.
Now, one thing I can say about this hearing here, well, his approach to this script, I never heard anybody else do it the way he does it. With the no, you are the person and calling a name. That's definitely different. I have heard no other sovereign citizen do that. So I don't know. Maybe he made up his own. He made up a script and enhanced it. And then I had somebody in here just say, what was it? The Skype converser. Yeah, I appreciate you mentioning something about the infomercials that I make. And I started to put one in here, but the type of case, I was like, nah, I couldn't really think of nothing on it. So y'all have more soon. You know, I like doing that. So let's go in here and see what's going to happen next.
Sir, in Wayne County Jail, what's your name?
There you go.
Say your name.
Say your name, sir.
For me?
Yeah.
The beneficiary of the state. I'm here today for the state.
What's your name, sir? I don't know who the beneficiary is.
Excuse me?
What is your name?
I'm coming to appear as the beneficiary of the state, Your Honor.
Okay, forget all that. What did your mom call you? What's your name? I have no idea who you are, sir. Okay, well, you're gonna sit there until I figure out who you are.
I'm not under that jurisdiction to consent to the name, Your Honor. That's appearing under your jurisdiction.
Your case is then, because I'm looking for Mr. Pollard. If you're not Mr. Pollard, then you're not here, and the warrant will be for your arrest, and you can sit in jail till you rot for all I care.
That's fine, Your Honor, but that's
Deputy, you can remove him. He's not here.
He's not here today because he doesn't exist.
Okay, bye.
The all caps entity.
Good talking to you. Goodbye.
He said he can sit in there till he rot. Never heard any judge say that. So he's not messing around. He's like, bye, see you. I like that. I like that. He's cutting it off. Well, let's go back in again.
Ms. Drain, I have Ms. James here on Pollard. That said you were standing in for Erica Moses.
Yes.
Okay. Ready? All right, ready on Pollard.
Calling case number 240-55381, the people of the state of Michigan versus Kevin Pollard. Defendant is being charged with count 1, criminal sexual conduct, second degree. Person number 13, defendant 17 years of age or older. SOR notice. Today is the date and time for.
Please remove your sunglasses.
Appearance
For the record, please.
Good morning, Your Honor. Shelley Drake for the people, number 60249.
And good morning, Your Honor. Nicole James, appearing on behalf of Mr. Pollard. Judge, I would ask to waive his presence if he is not in the courtroom. He is in the Wayne County Jail.
Court will waive the defendant's presence. Today's the date time set for a competency hearing. Did you get anything back from the forensic center?
Yes, Your Honor. The report indicates that Mr. Pollard is competent.
Are you stipulating to those findings?
I am, Your Honor.
Okay, the court makes a finding that the defendant is competent to stand trial. What's your pleasure?
Judge, we would ask that it be set for a preliminary examination date.
Court will continue the plea of not guilty and set this matter for preliminary examination. How is March 27th at 12:15?
Judge, I'm out of town all next week. My first available date would be April 4th.
That's going to be a problem, Ms. James, because the court is, that's my homicide day, and the court is closed April 5th.
Okay.
Okay, welcome, Jalen player. Huh? Welcome. You became a member. Now you part of the trust. I appreciate it. Check out the community post because it's something good over there, okay?
Judge, I'm out of town all next week, and then on April 1st, 2nd, and 3rd, I'm in a trial in Ann Arbor.
April 8th, that's my last offer.
April 8th is a good date.
April 8th at 10 o'clock.
10 o'clock, yes.
We continue.
Okay, thank you, Your Honor. Have a good one, everyone.
All right, we're going to let it ride. We go to the next one.
Mr. Pollard? Yes, sir. Thank you. He's not finished yet. Just the order next to your time.
Calling case 2455381, people of the state of Michigan versus Kevin Theron Anthony Pollard. Defendant is charged with count 1, criminal sexual conduct, second degree, person number 13, defendant 17 years of age or older. Appearances for the record, please.
Thank you, Your Honor. Erica Moses on behalf of the people, 78491.
Good morning, Your Honor. Nicole James, hearing on behalf of Mr. Pollard.
Kevin Pollard.
All right, today's the date time set for preliminary examination. Are the people ready to proceed?
Did he just say Kevin Pollard? He didn't say none of that stuff today.
Your Honor, I am not. I contacted the court via email as well as Ms. James to let the court know that Ms. Alexander Grayson and her daughter Nayla are out of the state this week. They will be back on Friday. She said she'd be available then or anytime next week, Your Honor. And I do apologize. They are on board prosecuting. They will be present. They just cannot be present today as a short term.
Judge, I would indicate that we were last here on March 20th and the preliminary exam date was set on that date. I would indicate that the prosecutor did send an email out on Thursday. Judge, I do not believe that is good cause. This date has been set for some time. I would ask the court to dismiss this case without prejudice.
So I want to make sure Mr. Pollard knows exactly what's going on here. So Mr. Pollard, when this court set the date for the preliminary examination, that date was set without the people contacting the witnesses at that time. Sometime after you found out, and the witnesses prepaid the trip on the time. Although they're not here, they are interested in going forward with this. So this court can find good cause to adjourn the matter to the date that they're not back or are otherwise unable to proceed the case. The court also has the option of dismissing this matter right now, but because people indicated this, they have complaining citizens that are still interested in going forward with this matter. The case will likely be reissued, which means you could be rearrested again, and we have to start this process all over again. I look at your face, I know you don't want that either. Yes. So I'm inclined to go ahead and give them to Friday to present their witnesses and go forward. If they're not able to do so, in this case,
Judge, I'm not available on Friday.
no time Friday.
No, Judge.
I can do it.
16th or 17th?
Excuse me?
The 16th or the 17th?
Can't do the 16th, that's my homicide day. Now available on the 15th.
Judge, I have a full docket on the 15th. One of the reasons is because I have a jury trial set for tomorrow, so I have to quiet on everything.
Okay, we can do April 17th at 10 o'clock. Okay. We'll find a good cause for the adjournment. Thank you, sir.
All right, I was going to answer Deborah's question. It looked like Rob chimed in on it. Yeah, because what I was going to say is most jails, well, it depends. Because like you said, if they're in the county jail, it might not go that way. But other prisons, like when you have those kind of charges, they're going to separate you. Or if it's high profile where it's on the news, more than likely they're going to separate them because people in jail don't like that. So as you heard, witness wasn't there. So he's rescheduling it to this hearing. Now you're about to find out what's going on with the last one we got here.
On case 2455381 for State of Michigan versus Kevin Deron Anthony Pollard. Been discharged in count 1 criminal sexual conduct, 2nd degree. Person number 13 is in 17 years of age or older. Mr. Pollard, we're going to have you have a seat in the second row until the witness comes to the court. Sure. Cheers, sir. Did I get the appearances already?
Thank you, Your Honor. Erica Moses on behalf of the people from 78491.
And good morning, Your Honor. Nicole Jones on behalf of Mr. Pollard, P5896.
Mr. Pollard, tell us your name for the record.
Stand up.
Tell us your name, sir.
Stand up.
There's a date time set for preliminary examination. Are you ready to proceed? She be on again?
She went to get the young lady first.
Get her some roller skates. Are you people ready to proceed? It looks like it.
Yes, Your Honor, I just have one moment.
That camera is being moved up because witness is in there.
Before we began, she wanted it on the easy course. She could ID anybody, otherwise she wasn't going to begin. So she just wanted to look around first, and now she's in the question.
Okay, we're back on the record.
Thank you, Your Honor. The people did have one witness here, the complainant in this matter. I do have an issue moving forward at this time. I do plan on rewriting However, I need to get an out-of-state witness here in order to proceed.
Your Honor, with that in mind, we would ask this case be dismissed.
So order, the court will dismiss this matter without prejudice.
Judge.
Dismiss the order, Mr. Mayor.
Yes, Your Honor.
Well, I know y'all didn't like that one, but it was another witness problem. Now think about this though, because this witness was out of state. It's been 4 years. The only thing I'm going to say that the witness may not have wanted to start reliving something again, so they did not want to come to court. That's the only thing I could think, because that girl was young. So I don't know. That's the only guess that I have on this one. So as you see, I was like, well, I can't do no commercial on this. Now we ready to go to another court. Yeah, he is disgusting. Oh, yeah, let me answer the question. We're in Maritime this evening, okay? Maritime. That's where we at right now. The answer to that question. And I think Aqua Queen and I think Rob took care of it too. Appreciate that. All right, so the next hearing, as I explained, with Judge Morales. Now, let me give you a quick update real quick. Hold on. I want to get this up here. Okay. Hold on. I got to bring somebody out. I want to know, do anybody remember that guy before we move on? I covered him last year, November, during his active cases, and he was supposed to come back in December. He didn't come back. And that's what caused the warrant to be put on him. This guy filed so many motions. Like, I saw some of them, but it's just too many to post here. And depending on your screen, you're not going to be able to see this anyway. But he posted his bond back in March, shortly after he got arrested. So we're going to go into that hearing in case nobody's seen it before. He's representing himself, very respectful. Seemed like he did a lot of digging, but his charges was it eluding police, and I believe it was a firearm. Let me look real quick, because I wrote it down so that you would know. Fleeing police officer and unlawfully carrying a weapon. That's what it was. All right, so we're going to go into this one and check this guy out. You'll see what goes on. But after this, you'll be up to speed if you haven't seen this case before, because he is going to court very soon. And I will have his next court case up here. And I think they will stream it, so I'll have it.
All right, we're on the record in 21 CCR 221014 and 221009 State of Texas versus Antoine Jermaine Davis. Mr. Davis, this is a status update on your case. You are still representing yourself, correct?
Correct.
Okay, just want to verify that. Nothing has changed. You have not tried to retain counsel, and you're not requesting court-appointed counsel at this time, correct?
Correct.
Okay. All right. So we're here on a status update. Why don't you give me an update on what's going on with your case, and if you have spoken with the DA's office? You don't have to go into the conversation.
Yeah, I filed a motion to dismiss for lack of subject matter jurisdiction.
I see that. And your motion that was filed, I don't know if maybe it was the printer that you utilized, or something happened. A lot of the words are not legible. I cannot read half of it, just because of the way it's printed out, I assume. You might want to refile that.
Okay, no problem. I'll get that refiled today.
And if you want to have a hearing on it, you need to schedule a hearing for that particular motion with the court as well.
Okay, no problem.
All right. Any other update that you'd like to provide, Mr. Davis?
Not at this moment.
State.
The state reviewed the defendant's motion, Your Honor. I did email with the defendant. I said if he would like to set it for a hearing, he's more than welcome to do so. Other than that, I have no update for you.
Okay, thank you. All right, Mr. Davis, you're free to go. Refile your motion, and then once you're ready to set it for a hearing, please contact the court, my coordinator, Ms. Toller, and we can get it on a docket for hearing.
All right, thank you.
Thank you. You're free to go.
Okay, he took care of what the judge asked for those motions because he loves filing them, and all the sovereign citizens love filing them anyway. That's part of their protocol. File all the frivolous motions so you can throw them off. And you know, my attorney at Sovereign at Law video talks about all that, the commercial.
Sorry, I can hear you clear.
Okay. We're on the record 21 CCR 221014 and 21 CCR 221009, State of Texas versus Antoine Jermaine Davis Bay. Mr. Bay, this is your motion to reconsider. I've reviewed your motion to reconsider. I've reviewed the response and then your reply to the response as well. I'm going to permit 10 minutes per side for argument, and then I'll make a ruling at that time. So, Mr. Bay, you may proceed with any argument you'd like to make.
Dang, I forgot. Those of you who know me, every time the judge gives a sovereign citizen a time, I always stick the timer up there, and I forgot to do it this time. Shoot. So somebody just set a stopwatch and see how long he talks.
Okay. So this situation stemmed from an arrest from March 8, 2021, from a lawful arrest without a warrant. Sorry about that. Okay. This is a situation between hypothetical suspicion versus a concrete crime. Whereas in this situation, no concrete crime that took place prior to the unlawful traffic stop. Okay, the state has failed to even establish a probable cause for a warrantless arrest and search, and they had no justifiable basis exist to continue prosecuting this case. The charges of this case do not meet the requirements of actual concrete criminal activity as defined under Texas law and federal law. For one, the absence of a sworn affidavit of probable cause by the arresting officer further renders this arrest unlawful. An injured party or a complaint with a legally recognized injury.
Hey, Mr. Bay, my court reporter is having a difficult time understanding. If you would face the camera, that way your voice could be heard clearly. Thank you, sir.
Okay. Can you hear me clearly now?
Yes.
Okay.
Just maybe slow down just a hair on your speech. Thank you, sir.
Okay, no problem. Okay, well, I'll just repeat what I said. So this situation happened from an unlawful traffic stop without a warrant or a concrete injury from an injured party prior to the traffic stop. I want to make a note also that the traffic stop and the other offense of possession of marijuana was dismissed back in 2021, approximately around the time when the case was first initiated. I did upload and file on record evidence of that notice of rejection as an exhibit. Also, I want to point out the fact that this is a case of hypothetical suspicion versus a concrete crime. Okay, the mere act of a traffic stop does not constitute probable cause for a broader detention or search as recognized by Terry versus Ohio. Okay, hypothetical suspicion does not equate to criminal behavior. Okay, in Texas, arrest or search without evidence of a crime of probable cause contravenes Texas Code Criminal Procedure Article 14.01, Section B, which requires that an offense be committed in an officer's presence or viewed to justify a warrantless arrest. The officer, Jazz Roberts, who was the arresting officer at that time, he did not have any probable cause or reasonable suspicion to even initiate the stop. And then once the stop was initiated, he didn't have any authority to continue with a search or an arrest, especially not just based off of mere traffic citation. Like I noted, that traffic citation was dismissed, okay, indicating that they didn't have any probable cause to prosecute a traffic citation against me. And also the adjoining case that was with it was a possession of marijuana, which was dismissed prior to even we having these hearings. Okay, I'll continue on. Failure to uphold due process requirements. Okay, due process under the 5th and 14th Amendment requires fair treatment through the normal judicial system. Protects against, due process clause protects against arbitrary government actions, including unlawful detention and seizure without legitimate legal basis. In Texas, due process violations occur when the rights to fair and impartial hearings are denied as well. And this is on the Texas Constitution, Article 1, Section 19. Okay. Also, the officer, as I mentioned, failed to sign an affidavit of probable cause, which is required under Texas Code of Criminal Procedure, Article 1505, subsection 2, which mandates that a written statement establishing sufficient factual grounds for arrest be presented and signed by the arresting law enforcement officer, which I requested a police report from Rosenberg Police Department, which is the arresting agency. I uploaded the results of what I received of that, which is pretty much a blank report. And it failed to have any attached affidavit of probable cause with it. Also, the prosecutor in the last hearing presented me with a discovery, which also failed to present any affidavit of probable cause. Okay. Okay. Also, unlawful search and seizure falls under Texas Criminal Procedure, Article 38.23. Okay. The prosecutor alleged the odor of marijuana. The odor of marijuana alone, without physical evidence of probable cause of actual crime, is insufficient to justify a vehicle search. Once again, was no testimony or affidavit of probable cause to.
Honor, if I may, I'm going to object to this. This is outside the scope of the hearing.
Sustained. Let's stay within the scope of your motion.
Well, this was all inside my motion as exhibits and as a brief.
Allegations made by the state were not contained in the defendant's motion.
Agreed. Sustained. Move on, Mr. Beck.
Okay. Also, the fruit from the poisonous tree doctrine applies to this case. All evidence obtained as a result of a warrantless arrest and search must be suppressed. Case dismissed under the fruit of poisonous tree doctrine, and that's Wong Sun versus United States, followed by citation. This doctrine.
Yeah, Mr. Bay, can you spell that name for my court reporter, please?
Yes, ma'am. Yes, sir. Wong Sun is W-O-N-G, first name, last name Sun, S-U-N. That's versus United States.
Thank you.
You can continue now. Thank you.
Okay. This doctrine bars evidence obtained from unconstitutional actions, including unlawful stop searches and arrests like probable cause. So for these reasons, I request that the court grant this motion for reconsideration to the motion to dismiss for lack of subject matter jurisdiction based on the due process violations, lack of probable cause, and other evidence that's lacking as well. Warrantless arrest, like as I mentioned in my motion and also in my brief. Okay, and I also request that if this motion is not granted, that I could get a full and complete police report to prepare for a defense. Also, evidence supporting the traffic stop and alleged crime that gave rise to this these charges that I'm facing with the evasion of arrest and charges of unlawful possession of a firearm. Because for it to be an evasion of arrest, it has to be grounds for an arrest for me to invade. There's no evidence of this. So with the incompleteness of discovery by the state and the failed documentation that the prosecutor failed to provide with a record of events that would normally be captured in a police report, I am prejudiced from preparing a defense, and I'm deprived of crucial information necessary to challenge the validity of the stop and subsequent search. So I do compel that full discovery, and I do request that this matter be dismissed for the reasons stated before.
All right, Mr. Bay, thank you. Your time is up.
All right, what's the time? What's the time? Rich was taking the time. What's the time? I got tired of him saying, and all of that stuff he's bringing up is not going to have no merit on what they're going to deny all that mess. What's the time, Rich? He'll probably put it up in a second, but yeah, I saw people talking about that fez he has on. Yeah, I don't know. Most of the time they in another color. Maybe he got his special order, but yeah, he's just bringing up all kinds of stuff that it's just not going to pan out for him.
Your 10 minutes. State, quick question before you respond. Has Mr. Bay had access to discovery in this case? He was admonished for self-representation already. Can you provide how long has he had access to discovery? Does he have access to everything in your file? Please.
Yes, Your Honor. That was actually the first point I was going to make in my response. Mr. Bay, can you confirm the email address that you provided on the docket control order that was signed on July 23rd, 2024?
It was Antoine Davis Bay at gmail.com.
Will you spell that, sir?
That's ANTOINEDAVIS. Last Bay BY at gmail.com.
And Mr. Bay, is that the same email address that we have received responses from you on October 23rd, November 6th, and November 13th?
Yes, it was.
That is the same email address the state sent you discovery, which would include the PC affidavit that was signed by the arresting officer, as well as the complete offense report that you just told the judge that you did not have access to. That information was shared with you to that email that you just confirmed on October 19th.
I never received any email with a police report, and I requested the police report over 2 years ago.
Did you request it? Who did you request it from?
The Rosenberg Police Department.
Okay. Please send me, I will do my best, but please send me an email immediately following this hearing so that I can provide you a PDF of that document so that we're not going through our portal.
Okay, no problem.
Now, in response to some of these statements or allegations made by the defense, again, as I just made clear, the defense has had access to the discovery since at the very least October 19th, 2024. I can't speak to whether the previous prosecutor had shared any of the discovery. I know he was admonished, I believe, on the same date that the docket control order was signed. So we haven't been able to go through actual defense counsel for this, Judge.
Chris C., hello. No, it's not a really old case because he went to court all the way up until November of last year, and he did not show for his December hearing. So this is a follow-up because he just got arrested for not showing up for court. But yes, this court case has been going on for a long time because of all of his motions and things that he's filed over the last 3 years. So this case has been ongoing because of failure to appears and all of that good stuff. So no, it's technically old, but it's not done and over with yet. So he has another hearing coming up.
Again, I will send over in an alternative format the PC affidavit and the offense report so that the defense has access to a complete set of information. On the last setting, I believe it was November 7th, defense was provided copies of all the media, Your Honor. So he does have access, at least from my understanding, to all the discovery. Now, as to points made in his motion, first and foremost, Mr. Bay has not been charged by information with evading arrest. Mr. Bay has been charged with fleeing a police officer as well as a unlawful carrying of a weapon. Now, to his first point of hypothetical suspicion, I do not know where the defendant finds that within the case law. I have not found anything of hypothetical suspicion. What justifies a traffic stop in this particular case is reasonable suspicion. As seen in the PC affidavit, as well as the offense report, the officer had a on-view offense for a traffic citation, which was speeding. The officer attempted to conduct a traffic stop for said speeding, at which time the defendant failed to pull over as required by Texas law. That in and of itself constituted fleeing a police officer, which is in violation of the Texas Transportation Code. I believe it is section 545.421. At the time of the stop, the officers attempted to make contact with the defendant. They observed an odor of marijuana. There is case law stating an odor of marijuana alone is enough to support probable cause to conduct a warrantless search of the vehicle, which is precisely what was done here.
I object, Your Honor.
Give me your legal objection.
The prosecutor has failed to mention any case law support his allegation with his brief or anything.
The case law in support of that was in the response to your motion, defense.
Yeah, it was, Mr. Bay.
Can you please?
Case law makes it clear the odor of marijuana can justify a warrantless search of a vehicle under the automobile exception of the Fourth Amendment. And he goes on to cite Stringer v. State, Rocha v. State, Isaac v. State, and then he even cites additional case law, Cameron v. State. So it is cited in there, overruled. Continue.
Oh, we just let him have it. He's tired of him now. It's like, look, I'm tired of your mess.
Based upon the odor of marijuana, a probable cause search was conducted on the vehicle. Again, this is as alleged by the state, at which point in time, the weapon was discovered within the vehicle as well as the contraband itself. I do not know, again, going to one of the points defense made, I don't know what due process rights are being violated here, which would warrant either suppression or a dismissal as defense has requested. He's claiming that he has not had the right to a fair hearing. PC was found by the magistrate at the time the defendant bonded out. The state has provided copies of that bond paperwork, which was also sent to the defense at the time all discovery was shared. Again, I will re-provide that to the defendant in an alternative way. PC was found by the magistrate. So he's claiming he has not had he hasn't had a fair hearing, but the magistrate found PC at the PC hearing at the time that he bonded out. So I'm not quite sure what fair hearing he's alleging he has not had a right to. I know he also made reference to not being able to confront witnesses against him in his motion. We have not had a trial yet. No witnesses have been presented for cross-examination. I will say, and obviously I will provide this to the defense electronically, Your Honor. I wanted to, at the very least, bring this to the court's attention. I have two cases. First is Born, B-O-R-N-E, v. State. Citation is 593 Southwest 3rd 404. I have a copy of it for the court. May I approach?
You may. Did you get that citation, Mr. Bay?
Oh, yes.
Similarly, I also have Lewis v. State. Citation is 532 Southwest 3rd 423. In Born v. State, the court makes it clear that arguments such as those the defense is making are sovereign citizen style arguments, which have roundly been rejected by all the courts, all sister courts. In Lewis v. State, they make a similar point. And in that particular point, or in that particular case, rather, the judge appointed standby counsel for the defendant. The state wanted to at least put this on the court's radar in that there are certain concerns the state has based upon the filings made by the defendant, in that one of two things is either occurring. Either the defense is filing frivolous motions to delay the judicial process and attempt to coerce the state into dismissing these charges, or alternatively, the defense is unfamiliar with the judicial process.
Those of you who stay on my channel, haven't I said this before? On the research I did, this is exactly, and a lot of y'all watch this, you know that's what they do. All this time, it just goes and goes and goes until it gets dismissed. That's the whole makeup of what they do with these scripts. It's amazing that he even cited some law on that.
If the latter is the case, the state would be concerned if the defense wasn't provided standby counsel. That's what Lewis v. State is about, Your Honor. Obviously, it is up to the defendant and it is up to the court, or the court's discretion, rather. If the defense is going to claim that he's having a bunch of rights violated, I would want to guarantee that we protect these rights as strongly as possible. Again, if the defendant were so inclined, by perhaps appointing him standby counsel.
Anything further?
I have nothing further orally, Your Honor. I've made my points in my response to the defendant's motion. Again, this court unquestionably has jurisdiction per the Texas Government Code, as well as the court, or the Code of Criminal Procedure. Additionally, based upon the case law I provided in my written response, as well as orally on the 7th of this month, I believe the case law supports the further prosecution of these cases.
All right, Mr. Bay, although you have used your 10 minutes, I will permit 1 minute of rebuttal.
Thank you. First thing I want to address is the due process of that was violated. The prosecutor mentioned that I had a probable cause hearing at the time of the bond. That wasn't the hearing that I alleged that was a violation. I never received preliminary hearing. Never even entered a plea of guilty or not guilty. That hearing had never happened. We initiated this case back in, bond was filed in March 10th, just looking at the docket sheet, Judge. March 10th, 2021, bond was filed. A hearing for the initial preliminary hearing was not called. The complaint was not even filed until April 27, 2021. So that was a whole 2 months after I was even released on bond before a complaint was even filed and no hearing was ever scheduled. A hearing was scheduled for, I'm looking at the docket sheet, a hearing was scheduled for 7/23/2021. It was 2 hearings because at first it was 2 judges. Christopher Morales and another lady judge. Her name was, and excuse me if I don't have her name right in front of me. But the other case was counseled. The cases was at the same time. So one case was counseled, the other case, I guess, was still heard. And that's when the warrant was issued. But that hearing, we never had a rescheduling that hearing. Once I was arrested again on the warrant and bonded out, that hearing never took place. Also, okay.
That was 2 minutes, actually. So,
all right.
Cut him off.
I'm ready to rule. And then I have a question for you as well, Mr. Bay. So I'm going to deny your motion to reconsider. We're going to proceed with trial. And sounds like my understanding, you have had access to the discovery since October 19th. However, he is going to resend everything to you for you to review. My question to you, Mr. Bay, is would you like standby counsel to advise you during trial? They cannot ask questions of witnesses or assist you in that way in the trial, but they can provide advice to you to help guide you through the process.
Yes, I'm not waiving any right to counsel. I do reserve my right, Sixth Amendment right to reserve.
You've already waived the right to counsel. You stated you wish to waive your right to counsel and you wanted to represent yourself. We had a whole hearing on that, Mr. Bay.
Okay, so you're asking me, do I want to?
I'm asking you if you've stated you want to represent yourself, Mr. Bay. Okay, we had a whole hearing on that. You waived your right to court-appointed counsel, and you stated you wanted to represent yourself throughout this hearing. And I have confirmed that in almost every hearing that we've held in this case. Now, what I'm offering at this point in time is you can still represent yourself in this matter, but the court would appoint a standby counsel who could advise you during the trial. They're not going to participate in the trial, meaning they're not going to ask questions of witnesses. They will not conduct voir dire, but they will advise you regarding certain legal rights that you may have or on legal matters that may arise during the trial. Would you like the court to appoint you a standby counsel?
Yes.
Yes.
Oh.
So you are asking the court, I just want to confirm, you're asking the court to appoint you an attorney who will provide you advice through the course of your trial, which shall begin on December 3rd.
And I also request that I reserve all my rights. Yes, that's a yes to that question, and I reserve all my rights.
Well, you waived your right to court-appointed counsel already with that whole hearing we went through. But I'm still giving you a court-appointed attorney to advise you, okay? You understand?
Well, I never waived my right to the Sixth Amendment. To the Sixth Amendment.
The judge is getting frustrated. Just answer the question, which you already did. He's trying to confirm, and he can't confirm.
I can have my court pull the record if you like, Mr. Bay, but we're not going to. I'll tell you what. Do you want to continue to represent yourself?
Yes, I answered your question. Yes.
Okay. Well, you're stating that you don't want to waive your right. Okay, here's the thing. Do you want court-appointed counsel that's going to represent you during the course of this trial?
Like I answered the question. I said yes, I would take standby counsel, represent myself.
You're going to take, so you still want to waive your right to a court-appointed counsel and continue to try this case yourself, but you're willing to accept standby counsel to provide legal advice only during the course of the trial. Is that correct?
Correct.
Okay. All right. Okay. We shall proceed on December 3rd with trial. I will have standby counsel appointed to you. They should reach out to you shortly. Mr. Bay, I believe we have a phone number for you. Do we?
I did not see it on the docket control order, Judge. Let me just verify that.
All right. All we have is an email. No, we have a phone number as well in the docket control order. All right. I will have the attorney that I appoint as standby counsel contact you through your email and the phone number you have provided to this court on the docket control order. Okay, Mr. Bay?
All right.
Very good. All right. That concludes today's hearing. You're free to go, Mr. Bay. We'll see you on December 3rd for trial.
Your Honor, if I may, before we let defense go, I know defense, I believe it's been rejected by the clerk's office. That being said, I did see it. I believe he has filed a motion to suppress. I wanted to raise that to the court's attention. Would you prefer having that prior to trial, or would you prefer it run with trial, Your Honor?
We'll carry it with trial at this stage.
Yes, Judge.
We don't have enough time to hear it beforehand.
Yes, Judge.
Also, can I make a note that I will be filing a notice to appeal on this order, and can I get this order for in writing to preserve my notice to appeal?
So I made a docket entry. Do you have an order that you have submitted to go along with your motion to reconsider?
No, I didn't.
Okay. Mr. Bay, I'm going to ask you to file an order that goes along with your motion to reconsider. I'm denying it regardless, and I'll make a note of that on the order itself.
Okay.
All right. I'll see you on December 3rd, Mr. Bay.
All right.
I'm denying your motion right off the bat. So now, for those who may have seen it, and now for those of you who haven't seen it, we're caught up. So the next hearing is going to be, I don't know what stage it's going to be. I guess it'll go back to the trial, but he never showed up for that December court date, December the 3rd. That's why we are where we are today. So we'll check it out. And also, if those of you who like police traffic stops, police encounters, go to Epic Police Encounters, another channel that I have just for all of the police drama and all of that stuff. It's some solving citizen traffic stops over there if you want to check that out. And I open that for the purpose of requests on this channel. So I hope everybody have a good day, even a night. I should have threw a commercial in on that one because Aqua Queen, you did mention that he couldn't remember all that. He kept going, I should have threw that commercial in here just to say, hey, if you can't remember the script, get that implant and put it in there. For those of y'all who've seen it, more will be coming soon. And I'm just checking out the chat. I appreciate everybody for coming in. Thank you for all the subscribers that are here. Thank you for all the members that are here. And for the members, I want to tell you before we leave, please go into the community post because I have a new app that you can access. You just put the request in and then we'll be in something else. You have to download it, but it's good. Okay. And that way we can all hang out in this other app versus the one we've been using. This is going to be a lot better because it's through Google. So I'm sure you should have a Gmail or Google account. Anybody that's new that came in, check out the community post. Is over there and you can sign up. And once I get the alert, I'll let you in and we'll start hanging out in there. All right. Let me see. I'm making sure I always check the chat before I go in case somebody trying to say something. All right. Good night, Deborah. Oh, Harry, it should be a link in here because Aqua Queen just stuck that link up to the other channel. It's in there somewhere. She just put it in there. Where is it? Hold on. Let's see if I can pin this thing. Go up a little bit, Harry, and you'll see it. You can just click on it and go in there. Hit the like button if you didn't. If you did like the content on your way out. And I'll see you around on the next video, okay? Everybody have a good time wherever you're at. See ya.